Somebody go.
Welcome to the City of Farmers Branch Planning and Zoning Commission meeting. This is our study session meeting. We will begin with study session item A1, discuss regular agenda items, which takes us to item C1, consider approval of the August 14th, 2023 Planning and Zoning Commission minutes and take appropriate action. Commissioners, any comments, edits, typos? All right, no comments there. That takes us to item D1, conduct a public hearing and consider special exception request for a mixed-use residential development on approximately 2.97 acres located at 2427 Carrick Street and take appropriate action. Who'll be presenting?
That'll be me.
Fantastic.
Unless you want to present it. Okay. No. All right, it'll be me. I don't know, does anybody have any general questions right now on this item, or?
City still own that property?
Yes.
Yeah, own the property? Yeah. Yes. Thank you, Kevin. Yes, yeah.
I just wanted to hear you say it.
Yeah, no, city technically still owns that property, absolutely. Yes.
But that doesn't describe the agreement. But so what kind of agreement is there if this is being put forward, but they don't own the land yet? Is there a sale agreement already?
Yeah, Kevin, do you?
Basically, yeah, I know a little bit about it. We haven't actually executed or, we're still negotiating and we'll be actually haven't even drafted. That's what I'm asked to do.
Right.
The sales agreement for that for the eastern portion of that property that'll extend over to kind of south, take in kind of that east end of Carrick and a little bit of the existing lease property for where the Star Center is now. So you've got the east part will be part of this multifamily, which will be part of a general mixed-use type of development. That there's some future other parcels that the city owns can be combined with others that will eventually is being discussed as being part of an overall infill for that whole area. And then on the west side of this property is the planned and the leased property, or will be the leased property for the multi-sports center that we're developing with the Stars, one of its entities. So that'll take in primarily that western part of the property, and again, it'll extend over, I think, in past the western end of Carrick,
Right.
which of course is currently closed and abandoned, but hadn't been demolished yet. Just got blocked off right now until development occurs. I think the plan, as I understand, we're in the process of getting pretty close to letting the utility contracts to do some of the sewer drainage utility work. And I believe, Mark, correct me if I refresh my memory, but I think, because Harold was asking about this a couple minutes ago, I think we are undergrounding the electric along there, I think.
Good.
I think so.
That was a question I had.
That's right. I believe that's part of the plan.
Yeah.
A lot of those improvements are part of the improvements for the bond that were sold, part of the bond issue for that whole area, if I'm not mistaken. So part of that's being funded. And so that's kind of the general gist of how that is all going to develop out, based on, part of it being, of course, some of these requests being made tonight will be part of what we need in order to ultimately get the detailed site plan finished for that area. So this is all city driven project along with private developers to go along with it.
So all those utilities will be put underground, the big gray ones as well as the ones that are.
The big gray transmission lines are staying where they are.
Yeah, they'll stay with
So then the Star
It's
Center,
the distribution.
so the Star Center will be on one side of those transmission lines, and then this project will be on the other side. Is that
Correct.
the general?
Yeah, you may recall, you may have seen, they've actually did some relocation of those poles already, largely because of the I-35 Phase 2
Right.
project that's coming up.
Has there been any opposition to this?
no opposition to this, not that we've received.
Considering the city owns, the city and Dart virtually own all the property, city, Dart, and TxDOT pretty much own all the property around this.
And then the streets, right, it's all mentioned of some street escapements and that they're doing, but like Denton,
Denton Drive?
Denton Drive.
Mhm.
So is that going to be redone at all as a result of this, or will that stay pretty much the same as it is right now?
No, it'll be redone because of this. Denton Drive on, I guess what I would say is the west side of Denton Drive, that will be done by the developer. The developer will put that streetscaping in, they will put the on-street parking in. The other side of Denton Drive, that would have to be done by the city, so.
That's part of this?
Is that going down to 2 lanes in front of this apartment?
Denton Drive, do you remember?
Because it mentions in the other one, we're talking about that
Mhm.
Denton Road is under PD 86 is going to go to 2 lanes, but I'm
There's a-
having cognitive dissonance to reduce capacity by 50% on the same street we're putting in a 330 unit apartment building, right, which is the main gateway into Mustang Station.
Right, now, I'm not, we can look,
I'll
you don't have
verify.
PD 86. Let us verify on PD 86. PD 86 actually defines how that section of Denton Drive is going to be.
You know, I can see it north of Valley View, but south of Valley View, around Mustang Station and the train depot, you need all 4 lanes there.
Need all 4 lanes, okay.
I mean, just think of somebody stopping to make a left turn into Mustang Station, holding up traffic all the way back to Valley
Well,
View.
usually if there's 2 lanes, there's a center shared.
Well, it's unclear.
Yeah, you're right. I didn't see it in there at all, yeah.
I do know that in our comprehensive plan, as we had those discussions, that this section did come up as a target area in some of those discussions. I recall it was one of the ones. So I know that it's gotten specific attention to appropriately surface the area. And I did note that our parking allotments here are in excess of what's required and needed. So I think that will also
Well, that doesn't mitigate traffic on the street, but I also know, I ride on that Denton Drive there on my bicycle a lot. If it goes down to 2 lanes with cars parked there, it's literally unrideable.
Yeah, but I think the one thing you all got to remember also is that, so PD 86 was a plan development that went through this commission, and it went to city council, and it got approval. PD 86 would have outlined what kind of cross-section is required, needed along Denton Drive. Those are good comments that you have. I'm not saying those comments are too late, but PD 86 has already gone through all the proper channels. It's already, so to now, if there are not 4 lanes along Denton Drive, which again, we're gonna double check that right now, and it is being reduced down to 2 lanes, that is council's will. That is what council agreed to. That's what council moved.
You have to also look at the usage, because they're trying to turn it into a more walkable, sustainable. So by slowing that down right there, you're allowing more pedestrians to not worry about high-speed traffic, so.
And that's what they did actually on Valley View Lane also, which is currently under construction right now. That is, those lanes are being reduced down.
Correct.
So
Yeah.
it's, I know, it's,
Did y'all attend the State of the City meeting a few months back?
yeah.
And somebody asked the interim mayor the status of the road diet, which is also livable streets, the same thing. And he said, oh, it's dead. The crowd cheered because they don't want the streets to be,
Because of the underground utilities and everything that would have to be removed to narrow the streets, it would be like $1 bazillion to move the utilities for the
there's a whole
sake
bunch
of
of issues
surface
about it.
traffic. That's what I don't think anybody ever thought about.
I don't know, because actually we had that discussion when we did our tour in South Fort Worth, and they had that exact discussion, and generally those considerations are brought into effect, and usually it wouldn't impact those utility right-of-ways, those would be maintained. In almost all the cases where you're doing these retrofits for safer streets, the biggest difference would be a reduction, you know, again, on our comprehensive plan, and all of the documentation where they showed those, and to your point, those crashes and those fatalities, and those potential conflicts. But I know, again, that this section was particularly highlighted in that documentation. So I feel though it's gotten particular attention, not only to meet the requirements of PD 86, but also in terms of, to your point, making it more appropriate for that station area for people who are on bicycles or on walking to, you know, get to that station.
I just submit that if you take it down to 2 lanes and have parked cars, it is hazardous. way
Yeah,
more
especially for-
hazardous than it is.
Potentially for dooring,
Well, is
that's a
somebody
consideration.
For cars making left turns.
Is somebody gonna do a traffic analysis at some point for that?
That's all,
Change.
it was already done when they did PD 86. PD 86 would have looked at those streets and that traffic analysis would have been conducted at
So
that
they-
particular time.
Did they know this apartment was going in?
Yes, yes. And actually, all of PD 86 allows for multifamily. So multifamily is all taken into account for all of PD
Well,
86.
my recollection is we have always taken into account that we want it to be more walkable, for lack of a better term.
And they want the wider
Real term,
sidewalks.
Walkable.
Walkable is a real.
Okay. I thought maybe I made that up.
I'm sorry.
I'll
can I-
go grab the binder.
Yeah, let me get the binder. and
I
see.
will say, I know on the east side of Denton Drive, there's a city planned project to install, I believe it's a 12-foot shared use path along that side, so that'll help with pedestrian and bike traffic as well. Let me go grab the
Yeah.
code.
Yeah,
Sorry,
that would
Brandon.
reduce those conflicts in terms of what you're saying, because it would be, you would be off-street instead of on-street.
Okay. Well, it's a done deal, so.
Yeah.
But it does allow bicyclists on that 12-foot.
Yeah,
That's
yeah.
the whole point.
That's
of
the whole
12-foot, yeah.
point of the shared use path.
Otherwise, it'd be a 5-foot sidewalk, and that's really
I
just
have
for
no argument
pedestrians.
with it. I think it's smart, especially for the people that live there.
Any concerns about any of the special exceptions at this point, or we can just, if you have questions, you can.
I noted that, I mean, it's part of the COP program, I know Roger hears this a lot about the, some of the hotspot areas in the city are in the parking garages.
Yeah.
And it sounds like this design is specifically designed to prevent those kind of issues. You know, so it seemed like it was a really positive thing.
Yeah, it was interesting because we were just talking about that, right? I think at the last meeting about the wrap concept versus the podium concept, and this is a podium concept.
Talking about the vents on the sides,
Yes, sir.
Well,
Yes,
there-
sir. Yeah.
they,
Will there be some kind of ventilation as part of those,
Yeah.
vents or slats or whatever, I don't know what you call them, but
I think with the opening, with the amount of opening that they have, I don't think ventilation is required. But I'm going to let's let the applicant.
yeah, I
answer
had some
that.
questions in that area to ask about,
Absolutely.
like maybe ask them downstairs.
Absolutely, absolutely.
Do you have any idea on like a window of rent per unit? Do we have any idea of that, or any idea of, has anybody signed on for any of the retail below? Are they talking to any particular type of retail?
I think the applicant's probably best to answer that also. They can definitely provide like what that rental is. I do know that they've, and I think in the staff report, we do talk about that, but we do mention that there are studio 1, 2, and 3 bedroom apartments included with this item. So they can provide the rent ranges for sure, absolutely. And then also about the leasing for the retail.
What are the plans, if any, or are there, or considerations for the ice rink that we normally put in that one sort of southern end of it? Is that just being done
Pickleball.
away with, or be replaced with a pickleball court? Or what's-
No, no,
what's-
you
is there
know-
any plans or consideration around that? It's-
Yeah, I have not heard, no one's told me anything about that, but that's something that I can look into for sure. I mean, I know that's something that I think the city would see on an annual basis. Is there?
we've done it a couple, 3 times.
Oh.
Same 7 people show up every night straight.
No.
What,
really?
I
It's not
did
heavily
see that
used?
I did see for this year that they said that was, you know,
Yeah.
postponed and moved
Yeah.
to the indoor facility. So,
And that may be it. They may move that to just as an indoor option.
Parking lot at the senior center.
It's possible. I mean, I'm gonna definitely find out and see.
I just thought I'd ask what
No, that's a
happened
good
to it, where it
question.
went.
Good question.
We're just doing away with it or what?
I know what I read in the city communication was that the temporary, at least for right now, would be moving it inside to that facility, which, again, given even our weather situation could be, I know last year there were a number of days where it was not functional because the temperature was too high to maintain the ice.
Okay,
So,
okay.
so that's a consideration for sure.
I hadn't even thought of that.
I mean, it doesn't sound like it's being lost. I mean, if they're moving it indoors.
Yeah.
Probably sounds like a better option, honestly.
Yeah, it does, as long as.
An ice rink indoors.
Well, as long as the option is still available to the residents, I think that's
Absolutely. Absolutely.
helpful.
Nothing further? All right, well, that will take us to item D2, conduct a public hearing, consider a request for a specific use permit for a commercial amusement development on approximately 1.55 acres located at 2330 Jet Street, and take appropriate action.
Any questions on this one? Specific use permit request for a pickleball facility?
Yes. Right.
Go ahead.
There's some mention and discussion in here about escrow money being put aside and managed, or do we know any parameters around that? Amounts, duration, who controls it, when does it get used or not?
Yeah, all of those items would be outlined in the escrow agreement that's being coordinated with our legal department. It would require approval from city council. And just for some background, the reason for that is that one section of Denton Drive, like we talked about, does call for a reduction to 2 lanes and on-street parking. If the developer were to construct only that portion, it would sort of disrupt traffic there because it's so close to the intersection. So the city has asked that rather than construct those improvements now, the developer escrow funds. They have provided a cost estimate. It's still preliminary and we're working through those details, but the final amount will be provided at the council stage. But the cost estimate, I think, is for $24,000, and there would be a time frame if the funds aren't used, probably within 10 years, they'd be returned to the applicant.
Or if they go out of business or they cancel their project, but what happens?
The funds would stay in escrow for
Okay.
those 10 years. It would be on the city to construct at that point.
Right.
Do we know if these people have already purchased all this property? I know it's a different group, and I don't think there's city property involved. Is there?
No city property involved. I don't know that they've officially purchased the land. I think their contract is contingent upon the zoning approval. But the applicant will be here tonight to speak to that.
Okay.
And is it a chain or is it an individual?
This is my understanding is this is their first location. They're calling it At Fault Pickleball, and there aren't any other existing locations, but it would be similar to like a chicken and pickle, that type of development.
This is not the same group that's going to do it out of the lake, is it?
No.
Or the group? Okay,
At the boardwalk site,
right.
yeah, no, this would be a different group.
Okay.
What do we know about the safety along Valley View Lane? I know they mentioned it about putting up an 8-foot fence next to
Yeah.
those pickleball courts. Is there anything to prevent cars from just crashing through that metal thing or
We,
swerving to miss a pickleball or something that flies over the fence? Or
That's actually what I was wondering.
That's a great question. The fencing is proposed along the perimeter of the courts, and it's a little bit set back from Valley View. There's actually a landscape area with several trees being planted there, so that kind of provides the protection for vehicles between the street and the courts.
And how tall is that fence, or?
8 foot.
It's 8 foot.
Mhm. And that's, I think, to prevent pickleballs from flying into the street or anything like that.
Not a
It wouldn't be
fun
tall enough for me, but we're a pickleball player, so.
Okay, so I'm gonna ask
You could just choose a different court, right? That wasn't the adjacent court to the.
Has everybody in here played pickleball?
No, and I was actually gonna ask that,
No,
are they
'cause it's-
plastic balls? Are
Yeah,
they
it's-
like a
they're
wiffle
plastic.
ball with holes in it?
Like a
Trust me, I
wiffle
played, when I used to play tennis as a kid, I'm not trained in tennis at all, but I would hit the ball over the fence, and that was a really tall fence at
Yeah.
those tennis courts, but this is nothing like tennis, like, it's,
I've seen them on
Yeah.
TV.
it's
they-
almost like a wiffle.
I don't know, I
Yeah,
can't
wiffle
tell,
ball.
but
Yeah.
I saw like the pro pickleball something or other, which is, there's no way I could play
I
that.
just have some concern that a ball flies over and a car swerves to miss it, causing an accident or.
Or damage to the car? That's what I was
Isn't this a
wondering.
green belt right here where you're talking?
There is, yes.
So there's like 38 feet there, the
I
wiffle
don't know,
ball.
is it 38 feet?
It's about,
Yeah.
And at the narrow end is how much?
And then
The sidewalk's 5, so that looks like it's gonna be 15 there, but it's almost 40 over here, so.
Yeah, I'm not worried about this, it's over
Right,
here,
yeah.
I'm not worried about.
I don't know, you'd have to be really good at going the opposite way just to get away down the street, but yeah, I mean, that's a concern you can share.
You
It's
never
just-
know.
No, really, I'm saying, it's just the green belt, something like over here, you'd be like, oh, wait, that dude is terrible.
That'd be me.
You're right, you never know, that would be me.
That'd be me.
Especially they're gonna have a bar, a restaurant here, people may be drinking, who knows how the quality of their play might be after a few drinks.
That's a good, will there be an alcohol license here?
Yeah, they should, they're planning to have a bar.
Okay.
Yes, but it's more restaurant than bar. I think it meets the.
Yeah, they're intending to be a qualifying restaurant, meaning I think at least 50% of their proceeds come from food sales.
True.
Just saying.
Other questions? I will say I was at the MetroQuest Chamber and Allison presented on this, and it was well-received with that audience.
One of many pickleball developments that have been proposed, so I'm definitely excited about pickleball.
How does the fee structure work for private pickleball courts? Is it membership? Is it by the hour? I'm just ignorant.
Probably a good question for the applicant. They'll be here this evening. Typically, I think you pay a fee to rent the court for maybe an hour or so, but they'll have more information for you.
Similar to pool, like if you go into an open pool hall, you can put your ID down and pay the $7 or $8 an hour, and while you're eating and whatnot, it's just kind of a.
Or a bowling alley.
More than
right.
7 an hour, but yeah.
Yeah.
All right, anything further on this one? All right, well, that will take us back to item A2, Planning and Zoning Commission Training Session from City Attorney's Office. Take it away.
All right. All right, for those of you, let me formally introduce you. For those who don't know me, I'm Kevin Laughlin. I'm a partner at the law firm Nichols, Jackson, Dillard, Hager, and Smith. We have been the city attorneys for the City of Farmers Branch since October 1st of 2008. True. Coming up on 15 years. I've spent almost a fourth of my life as, on your city attorney team. So appreciate the opportunity these years. You were actually one of the first cities I actually started working for when I came back from Midland, Odessa, and came to work with Nichols Jackson. So been with y'all a long time. And during the majority of that time, I've been working with the planning department, doing most of the land use work on platting and zoning, writing the vast majority of the zoning ordinances over the last few years. So anyway, so gotten to know the city, have quite a bit of history here. So let me just kind of kick started. I will just tell you, I am not one of these guys that just laughs it up during presentations, generally because we don't have time. We've got, you've got a regular meeting that starts at 7 o'clock, so we're going to try to get through this as quickly as we can, but hopefully with as much detail as you want. Generally, we'll start off with kind of some general information. Texas Local Government Code, Chapter 211 provides about the city may adopt ordinances relating to the location, use of buildings and other structures, et cetera, height and number of stories, percentage of lot that may be occupied, that's your lot coverage requirements, your size of yards, courts, and other open spaces, that's your setbacks. Population density, you can actually, that's where you get into your density, a number of dwelling units per acre. And home rule cities, and additionally can regulate the bulk of buildings. What the heck that means, I don't know that any planner has ever been able to figure that out either. But I think that generally means the height and just kind of the compactness of buildings within a particular area. You can, of course, divide cities into districts, as we've done, various sizes, and do different regulations for different types of districts. Of course, you can, again, regulate what goes in those districts, different types of buildings, construction. You can, one of the things is you do have to make sure that those districts, as you set them up, are generally uniform across the board. Of course, we'll talk a little bit about planned developments that kind of varies that, concept. But you do need to use, regulations need to be reasonably, adopted with reasonable consideration for the character of each district and the peculiar suitability per particular uses. Of course, part of that overall concept of zoning is to make uses fit together in a logical, non-harmful fashion as best you can to kind of retain the types of retain property values Make sure uses are compatible with respect to health and safety between different types of uses. That's why, for example, you'll see step downs from more intense uses to less intense uses with different kind of zoning districts in between, and or different things like, for example, screening requirements between non-residential and residential uses to kind of help with that transition between different types of uses. That's what that last point is to do. Of course, your zoning regulations here in Farmers Branch, we call it the Comprehensive Zoning Ordinance, or as you'll often see it, the ZZO, as referred to by an acronym. And you can find it codified in Chapter 94 of the Code of Ordinances, which you can find online at municode.com, and just I'll get it municode.com, click on the map, click the codes, click on the map for Texas, go to F, get down to Farmers Branch, and you're right there in your Code of Ordinances. Chapter 94 happens to be, by the way, the very last chapter in the Code of Ordinances. Okay, one thing is, if a city adopts zoning regulations, you must have a planning commission. There's no ifs, ands, or buts about that. And particularly, certain general law cities, their councils can serve as a planning commission, but with home rule cities, you have to have a separate standalone planning commission. And of course, section 236 of the Code of Ordinances, which is the general administrative section of the code that has listing of all the board and commissions, is the area where you'll find the regulations specifically relating to the Planning and Zoning Commission.
Can you give a quick definition on what a home rule city is?
Home rule city, there's a provision, it's Article 11, Section 5 of the Texas Constitution that provides for cities with a population of 5,000 or more may adopt, or may create a charter commission, and then may elect to adopt a city charter. Basically, the difference, just kind of in a very 30,000 foot level difference, because I've got a friend who in another firm who actually teaches on the difference between general law cities and home rule cities. But the main difference is general law cities are basically like counties. Their authority, their statutory authority, is strictly limited to what state law tells them the authority is. Home rule cities, although there's some question about that anymore, given what happened this last legislative session, and there's my soapbox comment for the day. The home rule cities basically can do anything they want to save and accept anything that conflicts with state law or the state constitution. So unless or is preempted by state law. For example, years back in the up until about the mid 1980s, cities had general authority to regulate alcoholic beverages within their cities and set their own regulations. The legislature in 1987 adopted provisions of the Alcoholic Beverage Code its precursor. Basically said, nope, state controls, and we only get to let you do what we say you do in this Alcoholic Beverage Code, basically preempting cities from regulating alcoholic beverages. So, but aside from that, and again, given some of what you may have heard or read a little bit about the Death Star bill that got approved this past session, which attempts to greatly erode home rule authority above home rule cities. Other than until this past session, basically cities could regulate where the state said you couldn't, unless the state said you couldn't otherwise. Other areas would be like a lot of utility areas, and regulations are all, subject to state regulations, and can only be done by that. But that's, in general, that's kind of the difference. Basically, home rule cities have a charter, and their charter is what is their primary governing document, saving, accepting, and conflicting state law. Okay. Structure of the commission, you have 7 members plus 2 alternates. you serve 3-year terms that are staggered, so there's no more than 3 appointed in any given year. Your chairperson and vice chair are to be elected annually, and your quorum equals 4. Okay, so because you have 7 regular members, your quorum is equal to 4. Of course, that can be a combination. If you have some regular voting members who are absent, that can also mean it'd be a combination of, if you've got an alternate member that's sitting in, it's still 4. So, it does take an affirmative vote of 4 votes to approve anything. So you can't get down to 5 members and have a 3-2 vote, because a 3-2 vote would be, even though a 3-2 vote is a majority of those present voting, it is not a majority of the board. So basically, you do have to have a majority of the board, of the membership of the board, in other words, 7, and have to have a majority of that to approve anything. Of course, your meetings are open, subject to the Texas Open Meetings Act. Again, I'm not going to go into the Open Meetings Act stuff tonight. We covered that during the general board and commission training, so I will not be spending time, unless you have particular questions, I'm not going to be spending any time on it tonight. Yes, sir.
Just quickly on the action taking of an affirmative vote of 4.
Yes.
Is it acceptable for a commissioner to abstain from a vote?
Depends on your.
Because I know our charter with respect to
Well,
city council is different.
city charter
so-
applies to council members voting.
Yeah, I
It doesn't
understand.
apply,
That's
it
why I
does
brought
not
up the
apply to
question,
boards
how
and
does it
commission
apply?
members voting.
Okay.
If you're abstaining and you don't have a legal conflict.
Sure,
okay,
I
so-
understand, yeah.
And you don't have a legal conflict, it would essentially count as a vote against,
Okay.
because you still have to have 4 positive votes for something.
Okay.
So if you don't, except for city council, a vote in abstention is a vote against.
That's
the
why I brought
act.
out, just for clarification of the commissioners.
Yeah.
If you choose to abstain, you can.
You can.
Obviously, if it was something that you might be engaged with your work, you should probably excuse yourself
Well,
altogether.
yeah, I mean, if
but-
you've got a legal,
but in
now, if
general.
you got a legal conflict, obviously,
different-
it doesn't count either way in that instance, because you're like,
Right,
it's
right.
like being absent.
Okay.
But nevertheless, you still have to, and it may reduce the quorum a little bit, but it's still going to create a situation. But with 7 members plus 2 alternates, it's going to be a rare occasion, I would think, that you have so many people absent or in a conflict that you don't have at least 6 members present and voting, where you might, where that issue might come up.
Thank you.
Of course, obviously, some of your duties are to carry out the duties and powers that you're afforded under the comprehensive zoning ordinance. As a commission, you do have the approval of plats, plat approval. And you exercise such powers as may be time to time conferred by the city council. So we'll go through a few of those, but primarily, again, your primary 2 tasks are to review and make recommendations with respect to zoning ordinances, zoning regulations, and to approve plats. Okay. As you probably are aware, there is a specific statutory requirement with respect to approval of plats, or approval of zoning regulations, I'm sorry. First of all, there are 2 public hearings required, one with the Planning and Zoning Commission and one at City Council. Before the commission hearing, you have to have a 10-day notice that's sent to the property owners within 200 feet, as well as property owners within the zoning area being rezoned. So, because of course it is possible that for somebody to come in and request an area be rezoned that's larger than the area piece of property that they own themselves. And so there might be other owners within such an area that they would be entitled to, or if it's a city-initiated zoning case, the city would have to be sure that they're giving notice not only to those within the 200-foot boundary of an area around the area being rezoned, but also all of the owners within the area being rezoned. Before the city council, you have to have a 15-day notice published in the it's a newspaper of general circulation within the community. Cities and TML have been trying for years to get away from the newspaper publication and go to an internet publication. As you might imagine, the newspaper lobby has lobbied heavily and funded, I'm sure, quite a few folks over the years to prevent that from happening. Someday, because you're getting to the point now where a lot of newspapers and communities aren't publishing papers anymore. And so it's getting to the point now where about the only newspaper available is online. And so some of this is eventually going to change. The city council cannot act on any zoning case until they have received a final report from the Planning and Zoning Commission. So, for example, if you all hear a case and we've got we've gone ahead, we try not to do this, but occasionally it happens. We go ahead and publish the notice for the council meeting. If for some reason the commission decides, no, we don't want to vote on it tonight, we're going to defer it to the next meeting, then, and if that next meeting happens to be after the council meeting at which the public hearing for that same item has been posted, the matter cannot be considered by the city council at its meeting. You have to wait until the commission acts on the case because the council must have a recommendation or at least a final report from the Planning and Zoning Commission. Occasionally, there is a requirement that city council may have to, when they hear a case, they may have to have a vote by a supermajority, and this is triggered in a couple of manners. Primarily in Farmers Branch, it's if 200 people, if the owners of 20% of the area within an area being rezoned file a required written protest in the form that's required by the CZO, or if owners of 20% of the area within that 200-foot band around the area being rezoned file that written protest. Farmers Branch, the CZO, requires a written protest be filed, at least I think we've got it Monday. And it requires a certain form, and it has to be from the owner of the property. I think we make allowances if it's a residential property. I think we make allowances that if it's a community-owned, community property type interest where you've got a homestead, husband and wife, one can sign for both. You don't necessarily have to have both signing. But otherwise, you may have to have all the property owners signing, unless we presume otherwise. But in any case, you have to have that protest filed by noon before the day of the hearing, primarily because in order to do, gives the staff an opportunity to determine that whether they've hit that percentage that's required to trigger the supermajority vote. Okay. We rarely have it here in Farmers Branch, but just in case you know, those who receive the notice who are entitled to receive the notice are those property owners who are on the tax rolls for that tax year, on the city's official tax rolls, which are determined as of January 1 of that tax year. Okay, so so people, if you happen to be a zoning case that's on the edge of the city, and that 200 foot happens to go into Addison or Carrollton, people in Addison, the owners of property in Addison and Carrollton are not entitled to that 200 foot notice. Likewise, tenants are not entitled to notice of rental properties. It's only the owner, the party that owns the property that's on the tax rolls is entitled to that public hearing notice. Okay. Other cities, just as an aside on that protest, in other cities, and this is allowed by the local government code, if the planning commission provides a negative recommendation to city council, that can also trigger the 3/4 supermajority vote at city council. Farmers Branch does not have that provision in CZO, and not all cities do. But state law does allow for that if the city council at some time would want to amend the CCO to provide for it. New provision in state law kicked in June, dealing with non-conforming uses. And I've actually already run into this with a couple of cities. And what happens now, under state law now, effective in June, if a zoning ordinance change, if a change in zoning regulations may result in a property being rezoned in a manner that it becomes a non-conforming use, then the city must provide this 10-day written notice by mail to those property owners. And the law provides those owners of real or personal property. So basically, that also means, in that instance, tenants would receive, business owners potentially could be required to receive that if their particular business within a property would become a non-conforming use, even if they're not the owners of the property. And so that requirement now that went into effect, like I said, in June, immediately after the session, the governor signed the bill. It didn't wait until September 1, like the vast majority of bills will do. Yes,
The hearing you referenced in the first bullet there, is that the
It's the same- it's the
P and Z hearing or the city
Both.
council?
both.
Okay, thanks.
Both. So, of course, non-conforming uses, as we know, are allowed to continue until they either terminate, through disuse, usually after 180 days, 6 months, or the city or some other government buys them out. And now you've got to buy them out if they don't terminate on their own through change in use, through disuse, discontinuation of the use. So, and of course, that concept of having to buy a non-conforming use to terminate it early has been around in law for many, many years, many, many decades. But now it's now been codified that that's what you have to do. So you have to go through a whole hearing process and an appraisal process. You may allow them to amortize, those kind of things. Frankly, I don't know, except in the most extreme circumstances, any city that we will ever represent that will go through that process. They will generally allow those, if they don't go out and just buy the property up outright to begin with, they'll probably just allow them to continue to develop, like a lot of times, through the normal change process as time goes on. Failure, though, to provide that notice can be a bust in your public hearing. What's going to happen is, as cities go through and look at their zoning ordinances and particularly looking at their use charts, as they revise zoning ordinances over time, they're going to find that, if they start adding, not so much adding uses to a district, but if you start eliminating uses from a district, from a particular, say, for example, if you were, say, take our light industrial LI district here and start taking taking uses that are currently permitted out of that district, then you're going to have to, before you can approve that, you're going to have to do an assessment of all the uses in every LI district in order to determine who's going to become non-conforming, and you have to make sure, because you're removing that particular use, and you're going to have to make, you're going to have to give that notice to all those property owners. Yes?
What if you did that 11 years ago?
Doesn't matter. It's only going forward.
Okay.
It's only going forward.
Because you remember when we took those 29 industrial properties between Webb Chapel and Marsh, and the only person that came to the hearing was that big warehouse on the corner of about Surveyor and Beltline.
Boy, you're going back a way.
because-
Even I've slept a couple nights since
Well,
then.
we took industrial property
Yeah,
and we raised the zoning to retail.
yeah.
And I think that property is grandfathered in.
Yeah, they
as
would
long as
be.
they operate the same business in it,
That's correct.
and they still do.
Yeah.
But all new development around that property is currently zoned retail.
Yeah. And that's what would happen, and you would have to, and of course, you allow them to continue that use for as
Right.
long as they continue that use.
Right.
Or unless you buy them out and to create a situation where you discontinue the use. So the non-conforming use itself doesn't change, but just the mere fact that they might become non-conforming use at this point means you may have to go ahead and give them a particular notice, a special notice they wouldn't, and that's in addition to the other public hearing notice. So, or either that, or I think one case we did, we actually kind of combined the language into a particular. But see, that not only occur if you remove a particular use, but if you go from a permitted use to a specific, and call it a specific use permit and just change it down to, you're not removing it, but now you go from permitted to making the specific use permit being required. That would also make it non-conforming use because because if it's a permitted use now, if tomorrow you made it an SUP being required to do it, it essentially becomes a non-conforming use because because they don't have the SUP, but for this non-conforming status, they become an illegal use. So you have to, cities now are going to have to be very careful and pay attention as they change their use charts. Adding a use is not a problem. Adding uses to use charts or adding something that's prohibited and making it SUP, that's not a problem because because those aren't going to create non-conforming uses. It's only when you start reducing uses or changing from permitted to SUP that's going to create the problem with this. So we're cautioning. So as time comes on, we begin to do the next round of review of the CZO and our zoning districts, our zoning district boundaries and the uses within the different zoning categories. This is going to be an issue we're going to have to pay attention to now, whereas in years past and decades past, we never had to. We just did it. So, all right. One thing about zoning, it is a legislative discretionary act. And because it's legislative, it means you're not mandated, and city council is not mandated to adopt any zoning change. Okay. So it is discretionary. And as a result, because it's discretionary, you can adopt it for any reason or no reason at all, or reject it for any reason or no reason at all, as long as it's not an illegal reason. And we'll talk a little bit about that. There are certain reasons to, reject, there are certain reasons sometimes given to reject a particular zoning change that I would say would be marginally, if at all, legal, particularly when it comes, because there are cities, for example, who've been sued over fair housing issues because of refusals to allow certain multifamily developments in certain areas of the city. Things like that. And so you have to sometimes be careful how, on certain zoning cases, you couch the reasons if you state them at all. So, but the general rule, 30,000 foot rule is, total discretion, total legislative. One thing is, as we know, we've recently adopted a new comprehensive plan for the entire city. Your zoning needs to be consistent with your comprehensive plan. Your comprehensive plan, of course, is, as you see, all the reasons that you adopt a comprehensive plan. This is the kind of the general basis. I'm sure you've heard a lot of this as we were going through the comprehensive plan adoption process and all the charrettes and everything was discussed going up to it. But these are many of the reasons that you adopt a comprehensive plan. One thing to remember, though, about a comprehensive plan, it is just a plan. The comprehensive plan is not, in and of itself, zoning regulations. And I think sometimes we lose that distinction between the CZO and the comprehensive plan. The CZO is supposed to be designed and adopted consistent with the comprehensive plan. The comprehensive plan itself is not a regulation. It's not an ordinance. Well, it's an ordinance, but it's not a zoning regulation, okay? It's kind of the overall policy document under which the CZO and its provisions and all the regulations, the plan development ordinances, and every zoning change is supposed to fall under, would be consistent with that policy document known as the comprehensive plan. Okay. Of course, I think you're pretty familiar, I'll blow through this, you're pretty familiar with all these requirements. One thing is, if it's not in the use chart, as we've discussed in a case not too long ago, if it's not in the use chart, it's prohibited. If it's otherwise, it's either going to have a permitted, it's going to be an SUP, and we have a handful of temporary uses that are actually identified in the use chart. But primarily, it's going to be either approved as a matter of right or approved pursuant to a specific use permit, which, as you see, the whole concept of specific use permit, some cities are called conditional use permits, others called special use permits. Here we call them specific use permits. The whole idea is it's a use that goes into a zoning district that kind of fits, it mostly fits, but it may need a little bit of tweaking on its regulations to make it consistent with the other uses that are permitted in the zoning district. That's the general concept of a specific use permit. So,
Is that where use by right, is that the same as allowed by right?
yes.
And does that, because it's a term I hear all the time, does that mean literally that if it's in there, if it's in there, you can't stop somebody from doing that type of business?
If it's already zoned for that use, and it's a permitted use within the zoning chart, that's correct.
Just allowed you?
It's allowed.
It's allowed.
So you'll sometimes hear cases, somebody will be coming, asking for a planned development district or a specific use permit, but primarily it was planned development districts, and they want to go for a different kind of use. Well, sometimes you'll hear from the applicant, and often you'll hear from staff, well, guys, here's what's being proposed. Now, here's all these things that are not quite as good as somebody could come in and develop it for, because it's permitted, and they don't need our permission. So sometimes you need whenever you're, and I hear this a lot. I see this a lot of zoning cases where you've got a base zoning that's very intensive, or maybe a planned development district that allowed a whole cadre of uses, many of which the city and they may have been adopted 20, 30 years ago when the city was either not paying attention or too small to really do what they should do, what they do today in reviewing planning, or like I said, the city just was going in a different direction 30 years ago and allowed that particular zoning. Well, now, 30 years later, the city's gone a different direction. You don't want it that way. So you do need to sometimes pay attention to what the permitted uses are in a use chart for the base zoning as it compares to the proposed uses that are set forth in the application. Because you may find out, and I literally have seen developers do this, they'll go and sell it for the permitted use that nobody wanted because they didn't get the use that they did want that would have been maybe not what the council wanted or what the commission wanted, but it was certainly better than what ended up happening because that other case didn't get approved. Now, I'll say that doesn't always happen because by that time, 30 years later, many times because of the surrounding development, market changes may dictate other kinds of uses than are what permitted as well. So, but just know, it is a factor to consider, when you're considering a case that's come before you. Yeah.
So with regards to an SUP is granted to the property owner?
No.
No?
It is a zoning amendment. It runs with the land. So
you can't attach it to an approved business as long as you operate this kind of business in this location.
Well-
Grant you this SUP kind of thing.
that is an ongoing debate I've had with planning directors and occasionally council members. And it to some extent, I will tell you, I have done that. And we've written ordinances, I've had cities pass ordinances that were tied to a specific business. However, here's why that doesn't make sense. I've also had to go back and have a zoning case because a business, the same owners came in and changed their business name. They went from being a sole proprietorship to an LLC. And because that specific use permit was tied to the sole proprietorship and not to the LLC, we had to go through a full-blown zoning case just to change the owner name. Here's the thing. If you approve an SUP based on particular use, then what difference does it make as long as they continue, as a new owner comes in and does exactly the same thing, doesn't change anything? Everything's the same. Okay? What difference does it make? Because you're talking about a land use regulation. You're not talking about a business. Now, if you're going to tie it to a particular business and you're tying it to them because they have a particular business plan and business structure and business regulations, the way they operate, then what you need to do at the front end is tie that to operational standards and go into a lot of additional detail in your SUP regulations so that anybody who comes along later has to come in and operate on the same business plan if they were to take over that operation.
What about a multi-tenant building? Where on one end of the building, to have this operation, you have to get a special use permit.
Yeah.
Guy goes broke or his 5-year lease disappears. You may not be able to find another business to go into that space.
Correct.
Under that special use permit.
Right. Well, keep in mind, a special use permit is for that use. It doesn't negate the ability to do the other uses that are already permitted on that property. All it is for that particular use. So if you got a, if the property already allows for, as a permitted means, other types of uses, you can still rent and that SUP doesn't have any effect. It's only if somebody wants to come in and take advantage of that SUP would they have to come in and operate under the SUP regulations for the particular use for which the SUP was required.
Can the SUP expire?
Yes. Actually, the CZO, we added a provision a number of years ago in CZO, and you'll see in most of our SUPs, there's a particular provision in regulations that speaks to the expiration of SUP primarily through non-use. The CZO, we added a provision basically as a means to kind of, because of course, as we've, know, and particularly folks who are planners know, what ends up happening is because an SUP is a zoning regulation that goes to the land and not necessarily the owner, unless you somehow terminate that SUP will be there forever. So what we started doing with a lot of our cities is either specifically, I know like in Midlothian, we had a specific provision we would add to our SUPs. Here, we've actually got it embedded in the CZO, same in Allen. Allen, we do the same thing, where there's a specific termination provision. And effectively what it is, it's we treat the SUP in that fashion like a nonconforming use. And so if there's a discontinuation of the use for the 6 months, then the SUP terminates of its own. So if the use for which the SUP is given terminates, and they quit using it for that purpose, then the SUP itself will terminate. We also make allowances if the termination is because of some kind of fire or windstorm and other natural disaster, that period of time to restart is extended to give at least some allowances for somebody to come in and rebuild and restart the use. So it's not just, so somebody who, the use was not their fault, we do make allowances for that. But otherwise, and then if they don't, the other thing is if they go and get the SUP and don't come in and get a building permit or get a CO within a particular time, then it terminates. So they can't just get an SUP and sit on it and wait for somebody to come in and start. They've got to actually use it. And if it's a use it or lose it type deal. That way we don't have this whole, hundreds and hundreds. I mean, we've actually gone in a couple of cities. We did this in Richardson, where we've actually gone through and terminate SUP, went around, saw where all SUPs were, found properties where they weren't using it for that purpose anymore, and repealed all those SUPs where the SUP use didn't exist anymore. Okay. Plan developments. Basically, plan developments are essentially a way to design a planning district that, for a particular area, I mean, they used to start out, I mean, the original concept of PDs, as I understand historically, were to basically be for purposes of developing large mixed-use developments, hundreds of acres. Well, over time, cities have, the PD has evolved to a point where many people, some cities are using PDs on a property-by-property basis. Some cities, for example, have a particular, I'll just use Midlothian as an example, since Marcus and I are both familiar with them. They have what they call a UVPD. The UVPD is designated primarily, the whole purpose of that was primarily, they've got a residential area, old residential area. Houses are 100, 125 years old in some instances, kind of historic, but it's not residential. It's not conducive to residential many times anymore. And so what's happened is, over time, people have to come in and renovate those houses. They've come in to renovate them and turned them into maybe professional offices, dentist offices and lawyers and massage therapist and whoever. Got one that did an ice cream store, with walk-up window in a house. And primarily, we do it on a property-by-property basis and create regulations within this particular area of the city near their old downtown that allows for the adoption of regulations on a planned development basis. So that it's not subject to the SUP requirements. It's an actual planned development. Of course, planned developments that run of the mill are generally, as you've seen, to establish a set of regulations that are customized for the particular type of use and development that's intended. That way, it makes allowances for some of these transitions that occur between adjacent properties that might not otherwise be allowed or even possible under your existing CZO regulations, which are intended to kind of take care of most areas, but because of the way development occurs and evolves, as we've seen, then it becomes a situation where you want to be able to customize, because it's something you want to see happen as a city, but you don't want it to just be anything the developer says anything goes. You want to have some level of control, especially as far as density, circulation, screening, how you do your mixes between uses, those types of things. Because a lot of times your base zoning is not going to allow for that, and particularly if you've got multiple type uses that would actually fall into different base zoning districts, you want to be able to kind of design that in a team with the developer as best you can work with the developer, and hopefully most of them around you can, in order to be able to get the kind of positive development that you want for your city. And again, I think so. Basically, the application process is just like any other application process. It's usually accompanied by a concept plan or site plan, and may also include landscape plans, sign plans, building elevations, and those types of things. Of course, while building elevations now, as you know, don't have quite, they're still important. They don't have quite the impact or regulatory effect as they used to here about 4 years ago, when the legislature took the city's ability away to dictate building materials. But you can still dictate what buildings look like. However, whatever building materials they use to get there, as long as it looks like that, we're good. Okay, so that's basically kind of what we're left with on building elevations. But in any case, different, of course, different types. You've seen, if you've reviewed the PD 99, PD 100, plant districts, there's a lot of detail in those. Of course, we now have what's called form-based codes versus just the regular Euclidean type of zoning. And so form-based codes, great, even more flexibility. They're more focused on, again, what a development looks like and how it interacts, not so much on the uses as, per se. And so that's where, you'll see a lot of the detail. Of course, I'll just tell you, frankly, from a legal standpoint, form-based codes drive me nuts because planners like to be very creative. They're very artistic and creative people. And while I may be quite creative, my creativity is limited to words that mean something and that you can enforce. Marcus has heard my phrase a lot. Again, and remember, Marcus and I worked together in Midlothian. He was on the Midlothian staff for a good number of years, and we're the city attorneys down there too. And actually, until about a year ago, lived in Midlothian. So we, see each other all the time, and objectively determinable is my phrase. Because notwithstanding anything else, even a form-based code at some point may have to be enforced in municipal court. And you have to enforce that stuff beyond a reasonable doubt if you're going to find somebody guilty. And it means it has to be, and you can't have a lot of vague language that won't mean anything to a jury or can mean 10 things to a jury. So anyway, again, my soapbox moment. Now, one thing we do is required of plan developments is once we've approved the ordinance and we have an ordinance in place, we have a concept plan in place, we then come back through the process to put a little more detail, because the plan development may not have all the details, because typically developers will not do all the engineering, all the architectural work at the time of getting their initial zoning for a property. That's delayed for a later stage where once they've got their zoning, now they know they can go forward with the basic concept of the development they're going to work with. So what they have to do now in Farmers Branch and the CZO and a number of other cities is they come in with a detailed site plan, get a little more exacting on where the streets are, where the buildings are going to be, what are the buildings now really going to look like, is a little more detail on the elevations. Where your sign's going to be, so effectively where your utility is going to be, how are you going to access, all that kind of stuff. So we provide for full detailed site plan. Detailed site plan is not in and of itself a zoning amendment. So therefore, you still have to happen. It's still part of the zoning regulations, but it's not necessarily an amendment itself to the zoning ordinance. So we bring in, so it's approved in Farmers Branch, it's approved through this, by the CZO, it's approved by resolution. Recommendation of Planning and Zoning Commission goes to City Council for approval. Does not require a public hearing. One thing about detailed site plans though is, and you need to remember, and we'll get into talk about plats, if it conforms to the zoning ordinance, basically you're pretty much, like plats, you're pretty much need to approve it. Still some discretion in there, but if it generally conforms with all the regulations for zoning, you're pretty much required to approve a detailed site plan. So if you don't like if you were on the losing vote of a recommendation because you didn't like the PD to begin with, that's fine, but you can't now at the site plan stage try to reject it because you don't like the uses, because that decision's already been made. Zoning's already in place. So you're a little late to the game on that one. If you were on the losing side of that vote, I'm sorry, but the use is already allowed. So the best thing to do at this point is make sure it's designed as well as it can be consistent with the zoning that was adopted. You can't get a building permit for development until you've got a detailed site plan. And of course, there's the whole list of requirements for what needs to be contained in a detailed site plan. I'm not going to go through all the listing and the criteria, but just know, again, it has to be consistent with the concept plan, adds details, all this kind of stuff. So, all right. Anything else? That's kind of the stopping point on zoning for this point. And I'm going to jump off into talking about plats here real quick. Any more questions about zoning and the process and kind of what we're doing with that? Okay. All right. Subdivision plats. If you divide property into lots that are divisions of land of less than 5 acres with no access, doesn't require dedication of any utilities or anything, you have to have a subdivision plat approved by state law. That's not just local ordinance, that's by state law, local government code. Of course, again, 5 acres or greater, you can do by meets and bounds as long as no as long as all have access. Now, access has not been. I've looked and looked and looked. I have never seen an AG opinion or a state law case that defines what access means. But I think generally what that means is it's either got some street frontage, public road frontage, or at least it has an easement, a permanent easement to benefit the property that can get you to a public street or road. Okay? So it has to have some level of access. Can't be totally landlocked with no easement or other road getting you to that allows you access.
Kevin, is it safe to say that if they wanted to pull a building permit on a property like that they wouldn't be able to pull a building
Probably
permit?
wouldn't be able to do it.
Because then the property needs to be platted, right, in that case?
Yeah.
Otherwise, it's just undeveloped land,
Right.
I guess, for the most part.
Right.
for private.
Well, and this is part of the reason platting is required is because,
Usually the permit comes into play.
well, and some people will take advantage of unwary property owners and, who are, not trained in what it takes to own a piece of property. They'll go sell a piece of property, not, the unscrupulous of the world, and leave somebody landlocked with no means to access it, and then they'll blackmail them for access in addition to what they sold them the property for. So I'm sure this is a property owner protection kind of thing in many respects. But it's also a means to allow cities to plan in a normal, regular, planned, and organized manner. Cities can add exceptions to the platting requirement. Sometimes some cities will, they'll specifically exempt any subdivision created because the city purchases a piece of property for a street right of way or other public purpose. Sometimes it'll be, if a probate court orders a division of the land because of the heirs to a piece of property want it subdivided, there'll be some situations where cities will allow that kind of exception.
Kevin, do you have any idea if our city has that?
None of those exceptions.
None of those exceptions?
No,
Gotcha.
none of those exceptions.
Because I was running into that with the solar farm situation. I wasn't sure if
Yeah.
long story.
Well, we'll talk about that later.
Gotcha.
The primary authority under state law for approval of plats is, at least in Farmers Branch, is the Planning and Zoning Commission. You can also require approval by the city council. Typically, actually, state law kind of initially defaults to the city council, but many cities will adopt their ordinance and say, under state law, you can permit planning commissions to also do subdivision plats, approve subdivision plats. We're getting fewer and fewer cities that still have city council approvals or plats. It's now, until Friday, city councils could limit, could delegate through their subdivision ordinances, the approval of, administrative approval of certain kinds of plats, amending plats, and we'll talk a little bit about that, minor plats, and other kind of plats. Effective Friday, a city council can actually adopt a regulation to allow all plats to be determined administratively. Now, I've yet to hear any city council jumping up, doing it on a horse act, saying, ooh, me first, kind of thing, to have all plats handled administratively. But effective Friday, September 1st, state law will go into effect that will allow that option for cities if they so desire. The commission must approve with conditions, or deny a plat application based on technical standards and only technical standards. And if you're going to either deny it or conditionally approve it, you must state why. You must provide the applicant a written explanation, and that written explanation has to include specific references to your subdivision regulations or other law or other ordinances as to why it was conditionally approved or denied. You cannot just deny a plat for the sake of denying a plat. State law prohibits that, period. Again, like I said, you cannot deny a plat on the basis that you don't like the zoning. Can't do it. Against the law. You will get your city sued. Okay? So basically, if the glove fits, you must acquit. Sorry, you got to do it. You got to approve it. You must act on it within 30 days of the application being determined to be complete. That application is not considered filed until it's administratively complete, and that 30 days clock clicks on at that point. What does administrative completeness mean? Basically, it means everything on the plat that's required to be on the plat is on the plat, and all information that's required to be provided to support that plat application has been submitted. So once you have all of that, you've got to have it in hand. At that point, the 30 days begins to run. Legislature this past session has tightened that up a little bit. They also gave us they also relaxed a few things, but they also tightened that up because it used to be 30 days, plat. Cities could not request an applicant extend a plat application approval deadline by 30 days. Many times, and applicants could only do it once. Well, this past session, one of the things that apparently developers finally realized, hey, we can't always get our own acts together within the initial 30 days or even the initial extension. So why don't you let us have the option to extend as many times as we want? And so developers have now got that approved through the legislature. But one of the things that cities are now required to do, and we already kind of began doing this after the last session, is identifying and listing all of the things that are required to be submitted with a plat application. Whether it be, and it may not be traffic studies, but it may be drainage plans, it may be civil drawings, it may be all that kind of stuff. All those things now, effective Friday, and between now and the first of the year, cities have to actually adopt a list specifying all of those items that have to be submitted with an application. Something I've not talked to Marcus and Ryan about, but the two of you need to get together and start putting together that list. And to the extent that those things are not currently identified in our subdivision regulations, they need to be added. Traffic, I would say, traffic studies, we talk a lot about traffic studies. Traffic studies, frankly, ought to be done as part of the zoning application. Because it's really the use and the intensity of the use that often dictates traffic. It's not the layout of the subdivision. Many cities have tried to tie their traffic impact analysis to subdivision plats. Well, frankly, you're too late at the platting stage. That's really an item that needs to go with the zoning application. But other things, like I said, civil plans, for utilities and streets and all that, that are typically part of a plat would need to be required listed. And now you got to publish it on your website between now and beginning as early as you can after September 1, but in any case before January 1st. Okay. Yeah, I think we've talked that. Okay. Preliminary plats,
Was that where,
Go
I just remember there was a case where a commission member could be sued personally. And it seems like it was tied to not voting negative on a plat or something. There was,
I don't recall that case.
I don't recall where there's a situation where.
Now, I'm not so
commission
sure, I'm
member-
not so sure that couldn't happen.
Yeah,
If you had individual commissioners vote something down and vote a plat down that
yeah.
really complied.
If you don't remember that.
I really don't remember.
I must misremember that.
Yeah. Okay, different kinds of plats. Preliminary plat, I'm not going to talk too much about that. That's just, we don't have too much, we don't even do preliminary plats anymore. We deleted preliminary plats in Farmers Branch. Final plat, of course, is the final approved subdivision plat. Lays out all the streets, all the common areas, all of the lots, everything that goes with it. A replat is basically what a replat is, just a re-subdivision. It's a final plat that changes a final plat, is what it amounts to. And it can create more lots, create fewer lots, change the street directions, and all of that. A minor plat, 4 lots or fewer, no new streets or utility dedications. They already exist. Those can be approved administratively. Amending plats basically are for the purpose of fixing an error on an existing plat. Maybe you had a boundary call on a surveyor put the wrong, number of degrees in a survey call or something on a plat. Fix those, or fix a street name or a spelling, or even change the name of the owner because somebody forgot to change it. Those kind of things can be changed. Type of, Scrivener errors, basically. Those can also be approved administratively. One other that's not on here is what's called a conveyance plat. And it's kind of a plat and not a plat because it doesn't really allow any development, but it does provide for the layout of lots. And with a conveyance plat, you can actually sell the property by lot in reference to a conveyance plat. Now, you can't building permits, can't get any of you can't start building your streets. You still got to attain a final plat and go through all the final plat process, but you can at least go ahead and sell your property based on a conveyance plat. I actually closed a deal last week up in Allen, and that's all we used was a conveyance plat for a deal. And so, and developer's going to come back in and come in and build all the streets and do all the improvements after the conveyance. But in order to start the development, we had to get several owners had to actually get their hands entitled to the property first, so they can start doing their part of the development. You know what? I'm going to hit on a couple of things about public hearings, and then I'm going to stop. I'm going to go through all these slides because we've got about 8 minutes left. Give you time to get downstairs. A couple of things about the public. Well, first of all, any questions about platting, real quick? Basically, kind of sum up platting. If the staff tells you it complies, unless you're going to go do your own independent research on whether the plat really complies with all the regulations or not, then I think you probably better take it that, if your public works director, city engineer, and your planning director say it complies with all state laws, probably ought to approve it. Okay, just leave it at that. Couple of things about public hearings real quick. Public hearings, as you know, can get kind of rancorous. I think probably the couple of key things, and I won't go through all these slides, a couple of things about public hearings. Keep on a kind of a same kind of process. Staff, and organization. Let's do the staff presentation, applicant presentation if there is one. If there's questions that the commission has for staff or the applicant before opening public hearing, go ahead and address those. Open your public hearing. Have all the people, who are going to speak, come up and speak. Give them their 3 minutes. I suggest you keep them to their 3 minutes. Don't. I know councils and staff and commissions who will allow depending on the number of people speaking, may allow more or less. I would suggest you stay consistent with whatever your speaker rules are and give them their 3 minutes. Don't ask anybody for or any against, just call them up and let them decide if they're for it, and let them tell you if they're for or against. So that way you're not trying to, it doesn't look like you're organizing the manner or either the opposition or the pro applicant, forces. And then make sure speakers are addressing the commission. If they have questions, my recommendation is to keep an orderly meeting going. Don't address them right then. Have staff help write down the questions and then bring those questions back after you close the public hearing, so they can be directed either to the staff or applicant. I have found over the years that is the most orderly way to conduct a public hearing. Once the folks speak, they're done. They don't get a second bite at it. You've already they've already heard the staff presentation, the applicant's presentation if they have one, and some questions and answers between the commission and staff and the applicant. If they're going to say anything, they're going to say anything based on those presentations if they're going to make any changes. But once they're done, is my opinion. Now, because if you fail to keep to that, you run the risk of losing control of the meeting and extending it extensively. Not to mention giving those people more than the 3 minutes to which they were entitled under your speaker rules. So I would suggest, people who start raising their hands and doing the Horseshack thing from the gallery. Yeah, I'm glad to see there's people here old enough to know who I'm referring to. It's not.
Talking about Welcome Back Carter, right?
Absolutely. So it's one of those things in order to keep an orderly meeting, make sure everybody has their opportunity in a fair and equitable manner to have their say, and then they're done. Close the public hearing. Ask any more questions. I would go ahead and be sure you're asking the questions that were asked by speakers to direct them to either staff or the applicant. Make sure those are answered so the people who are sitting there who asked the question, you told them you're gonna, we'll have these questions addressed during, after the public hearing by staff or applicant. Be sure you do that. Because otherwise, the members of the public will not feel they're being given a fair shot at getting their issues that they're concerned about addressed. Now, they may not like the answer, okay, which is what typically prompts somebody to want to get back up and say something. But the answer is the answer, okay? And so they've had their chance to ask it, answered, they're done. Then have your discussion. You can say what you want about or say nothing at all about the case and why you're voting or not voting for a particular matter. Once you've done that, call for a motion. Be sure, I would suggest the motion be, again, in an affirmative manner. Now, in the case of a planning zoning commission motion, it could be, I moved that we recommend approval. I move that we recommend denial. Remember, you're a recommending body, so the motion needs to be, you're not approving or denying, you're recommending approval or denial, okay? So be sure that that's how the motion is. Keep in mind, if it looks like it's gonna be, you've got a little easier doing it that way, and I think it's cleaner on the record. I would recommend that if everybody's wanting to recommend denial, you still have somebody make the, make the motion. Somebody make the motion. Know that you can vote against your own motion. That's another thing. But get the matter disposed of and get a report out to the city council so the city council can now deal with it in a final manner. But get a motion done. Now, the only exception to that is if there's something that happens during the course of that hearing and you want additional information, or there's things that the commission, as their kind of consensus, that if the developer were to change something, then maybe the vote might change, and there's not any hard feeling against the developer application in that instance. My suggestion then is you do have the option to defer action on it to a later meeting to allow changes to be made. Unless it's a minor word change or two, my preference as city attorney is that, for example, if it's something it's a required change in an exhibit, an extensive change in an exhibit on a PD ordinance, for example, or an SUP ordinance, I want you all voting as city attorney, voting on what you're making a recommendation on. If you don't have that document in front of you that night, or there's something more than just a couple of minor tweaks that could be done between the time the commission votes and the time the council sees it, I recommend you defer action on it. Now, developers may not always like that. But, you know, my preference is I want you voting on I want you to see what you're voting on. Marcus has heard this from me before, staff's heard this from me before. I want that vote to be, I don't want anybody, particularly I don't want city council wondering whether or not you saw what has been recommended to them, one way or the other. Okay? Because sometimes that'll get asked. The planning commission see this, and we'll say, yeah, they deferred action on it, and we had the drawings redone, and this is what was in their packet for the purpose of making a recommendation. I want that, again, objectively determinable. I want to make sure you're voting on what you see. Okay, I think it's your best interest. I think it's city council's best interest, and so if it needs to be deferred in order to get that final action, so you're voting on what you're seeing, then do it, by all means. That's all I'm going to do for tonight. I know it's a couple minutes over, but I hope this has been helpful.
Oh, yeah.
You know, your meetings, as long as it's not on let's see, because I have conflicts on the first Monday night of the month. You know, save all the controversial ones for the third Monday meeting.
Will do. Will
Okay,
do.
so in case you need me to be here, I can be here.
Right.
Okay. All right, I appreciate y'all service, thanks.
Thank you.
All right, so up
Do we have to
next,
adjourn?
item, that takes us to item A3. We'll receive an update from our Planning and Zoning Commission Landscaping and Tree Preservation Subcommittee, LTPS. Thank you again for that, Roger.
So we had a chance to meet with both Kira and then meet amongst just ourselves last week. And we had a great meeting. So we have 2 people that are out for a couple of weeks. So our next steps are shooting to have a draft of some sort back by the end of September. So we all have our little projects and homework that we're all doing independently, and we'll circle back and have some sort of draft by the end of the month.
Yep, thank you so much.
Sorry, that's not all that exciting, but we got to meet. It was great. So,
Very much
Get
appreciated.
all the information you needed from city staff?
yes,
Okay,
yes, it was great.
Glad to hear that. All right, so that takes us to item A4, discuss agenda items for future Planning and Zoning Commission consideration. Commissioners?
I don't have anything.
Were we gonna have a update on the little trip down to the design district?
Oh, the design, yes. I think that's actually scheduled for, it's the 28th, but then we have a meeting with Dallas. We're trying to get a scheduled meeting with him next week. And next week, we're gonna finish out the details, and then the next P&Z meeting, we'll bring those details to everybody.
Thank
But I
you.
think we've already sent something to Dallas
Yes,
already,
sir.
right? Yes. Yeah, so we should be meeting with him next week.
Fantastic.
That reminds me, were you gonna give us any kind of update on the betterments project? I know,
Yeah,
gonna do now or later, or next time, I don't know, I just
well,
reading it in the
Yeah, we could,
pack it tonight.
right, yeah, we definitely, as staff, we've definitely exhausted all avenues. And let me just start with that as far as trying to get the information out to whoever we need to get it out to. We've contacted our CMO offices, that's our city management's office. We've contacted TxDOT. We've also contacted the Public Works Director. And at this particular moment, at this time, until we hear something back from City Council, then we'll know which direction to go. Now, I don't want to get this board mixed up with the task force. I know the task force was something that the City Council created, and this board here, really, there isn't, I don't know, actually, to be honest with you, I wasn't sure how the connection actually started between this board and Betterments, but Betterments does go directly through the City Council. So I think there might have been, we might have had a member here.
We had a member here introduce some construction alternatives
Right, but
to be considered, and I think it kind of
yeah, and I think.
flowed somewhere, I don't know.
Right. Now with city council, if the monies have already been, from what I understand, the design has already been created. So everything's already pretty much set in place on how that intersection is going to be designed at this moment. If there are any changes, it's really going to be upon city council to direct staff as far as like if we need to find out certain prices or if we need to alter the plan in if any way, that direction really has to come from them. So it's kind of like more like
Well, as I recall, was Commissioner Zavala had a contact with somebody
yeah.
that was in that planning stages on how to design, wasn't going to cost any additional money or anything like that, so.
And I think
Send us an email, hey,
yeah,
forget about this, and that's all I was trying to
right.
forget about, so.
We have not heard, I have not heard anything back from any of the folks that we have reached out to. Now, when I say reached out to, now, from what I understand, I believe some emails were sent out to the Texas Department of Transportation, but that was more to set up another meeting to talk. But from where everything stands right now, it is, it's designed the way it's designed.
It's your update, that's fine,
Yeah,
that's all we're
it's-
looking for is an
yeah,
update. so.
That's really, yeah, that's where we're at right now on that, so.
Thank you for
Yeah,
clarifying.
sure, no problem, absolutely.
All right, that then takes us to the end of our study session. It's 7:07, and we will meet downstairs and resume there. Thank you. Good evening. Welcome to the City of Farmers Branch Planning and Zoning Commission for Monday, August 28th, 2023. It is presently 7:17. We'll begin this evening with citizen comments. This agenda item provides an opportunity for citizens to address the Planning and Zoning Commission on any matter that is not posted on the agenda. Anyone wishing to address the commission should complete a citizen's comments registration form and submit it to the chair prior to the start of the meeting. There is a 3-minute time limit for each citizen to speak, with a reasonable limitation on speakers on any one topic or item, with a maximum of 15 total minutes on the same topic item. Anyone wishing to speak shall be courteous and cordial. The Planning and Zoning Commission is not permitted to take action on any subject raised by a speaker during citizen comments. However, the Planning and Zoning Commission may have the item placed on a future agenda for action, refer the item to the Director of Planning for further study or action, or briefly state existing city policy, or provide a brief statement of factual information in response to the inquiry. This evening, we have no one signed up for citizen comments, so we'll begin this evening with regular agenda items. I'd also like to thank the commissioners for their service. Item C1 this evening is consider approval of the August 14th, 2023 Planning and Zoning Commission minutes and take appropriate action. Commissioners?
Yes, I move that we approve the minutes.
All right, have a motion
Second.
and seconded. Any further discussion on the matter? Seeing none, we'll move to a vote. All those in favor? That carries unanimously. Thank you. Up next, item D1, we'll conduct a public hearing and consider a special exception request for a mixed-use residential development on approximately 2.97 acres located at 2427 Carrick Street and take appropriate action. Thank you.
Thank you, Commissioners, Madam Chair. The applicant in this case is seeking approval of 2 special exceptions for a mixed-use development located within Plan Development 86. This is located at the corner of Pike Street and Denton Drive.
This is the wrong presentation.
Looking at the wrong presentation here, I apologize. Let's pull this one up. Okay. I'm sorry, I saw D2 on it, so that is my mistake. All right. There we go. Thank you, Brian. So this is located at Pike Street and Denton Drive. The proposed development is 7 stories, consisting of 337 residential units. It's going to have 2 levels of podium parking. It's close to 9,000 square feet of ground floor retail space. As you can see, the design of the building is very modern. It's got a mixture of exterior materials, including masonry, metal, storefront windows, stucco, hardy board, plenty of articulation, as you can see from these images, that has been added, including cornice detailing along the roof line. The development will contain amenities such as decorative lighting. This is the type of lighting that the applicant is proposing from the ground floor all the way up to the 7th floor. In addition to that, the applicant is including outdoor decks. They'll have a swimming pool, dog park, and a good amount of open space. Here's a general overview of the project. You can see the outdoor decks that are located on the 3rd level, and more open space located on the south side, with access off of Pike Street and access to this garage off of Denton Drive. Wide pedestrian walkways will also surround this project with street trees, decorative street lights. The applicant is also proposing 24 on-street parking spaces. The podium parking should have approximately, I believe it was 506 parking spaces as well. So mixed-use developments are permitted by right within PD 86, and this allows staff, it also allows staff to approve site plans. But special exceptions do require the Planning and Zoning Commission's approval. So with that said, in this particular PD, it does require 15% of contiguous open space. The applicant has actually exceeded this by 28%, or actually they're providing a total of 28%, but it's just not in a contiguous fashion. With that said, we do think that the layout of what the applicant is proposing actually is probably more ideal by spreading that open space out and not isolating any one particular area. PD 86 also requires that residential and retail uses be located along Denton Drive, which is also considered a Type A street according to PD 86. Typically every 75 feet, you're supposed to have a functioning door that should be included along Denton Drive. The northern portion of this building has this, but the podium parking is exposed along the southern portion of Denton Drive. So the applicant is proposing, here's an example of what they're proposing, but it's decorative angled shutters that will add kind of this visual fan-like effect, and also allows for ventilation within this podium parking. So we talked about this earlier during study session, but unlike wrapped parking, podium parking has an advantage of an open design, and it will allow for increased visibility into the parking area. This visibility can act as a deterrent for potential undesirable activity. So as always, we do reference our plans, and in this case, the proposed development is consistent with our I-35 vision study and the Farmers Branch 2045 plan that we just approved. On August 17th, 16 notifications were mailed to surrounding property owners. Two notification signs were placed on the property. Staff has not received any correspondence regarding this case. Staff does recommend approval of the requested special exceptions as presented, and I'll continue to stand for any questions you may have.
Any questions for staff?
Where's the dog park? And is it fenced?
Yes, sir. Actually, if you look at this slide, let me see if I can find a close-up of that. So the dog park should be to the far, well, it would be my far right, I guess your far left. I believe that is the dog, is that the dog park?
It's the second one from the south, so the far right courtyard is quiet courtyard, and then the one next to the north.
With the two trees in the middle?
2 trees, yes.
The one with the two trees in the middle. And fenced?
And fenced.
Yes, sir.
Any other questions for staff? All right.
So the dog park on the raised platform, that would not be open to the public, and that would be specific to the apartment.
That is correct. Yeah, the open space, it doesn't necessarily, when we talk about open space, you have two different types of open space. Obviously, you have open space for public and you have open space that's private. PD 86 basically talks about 15% of either public or private open space. So particularly in this particular case, they are not only providing an additional amount of open space, but they are breaking it up. So it is allowed either or, sir.
Anything else for staff? All right, seeing none, I understand we do have an applicant here, and they're available for questions. Is there an applicant presentation?
No applicant presentation, correct? No applicant present, but they are ready for any questions that y'all
Okay.
may have for them.
Commissioners, do we have questions for the applicant? All right, if you wouldn't mind, please state your name and address for the record.
Work address or personal address?
Work is fine.
I don't remember it. Josh Eames, I'm Vice President of Development at Presidium and 3100 McKinney Avenue in Dallas.
Thank you. And commissioners, what questions do we have?
Sure. Then the Denton Drive, what is your understanding of how that is going to be redeveloped or changed? And how do you feel, I mean, how does that relate to your property?
Well, we've been working closely with staff, I'd say for the last 9 months, if not longer, on making sure this development is in concert with the redevelopment of Denton Drive. And we understand the city is going to take the lead in basically redeveloping everything from back of curb across Denton. So we've worked closely with them. Our engineers have worked with the city's engineers.
So what is your, I mean, I guess what is your, how would you describe, how do you understand that that's going to happen?
Oh, it's going to be much more pedestrian accessible and pedestrian friendly, and, you know, provide an opportunity to connect to Mustang Station, the station itself, and the development to the east of that.
Go ahead, Roger.
Just to Marcus's point there, there's mention of having wider sidewalks. Just how wide are you talking? 8, 10, 20 feet? What do you? 8 feet. About 8 feet wide? Okay.
And that's in the right of way, right, Larry? 8 feet in the right of way?
Along Denton Drive, it'd be 8
We
foot?
will still have a few feet beyond the right of way, between the right of way and our building.
There's also mention of the ground floor retail.
Yes,
What was it, roughly square footage?
9,000 square feet.
And do you have any potential tenants at this point?
No, we
considering-
haven't
No.
gotten
Haven't got that far along
in
yet?
the
Okay.
process. But we anticipate, given all of the retail to the east and the accessibility to Mustang Station, it would be successful.
And my last question is regarding the parking, I think you called them decorative shutters.
Mhm.
Within that parking area, is there any forced ventilation to move the air or the carbon monoxide from the vehicles to sort of exit that area? Because I noticed in the photographs, there's a lot of pedestrians in that area. I just didn't know of any
No,
impacts
there-
around that.
As Marcos mentioned, the calculations for the garage indicate it can be an open-air garage, which doesn't require mechanical ventilation. And so we worked with Marcos and staff to develop a cladding for the garage to make sure that open area stays in place, so there's no ventilation required.
Thank you. That's all I have.
Hi. Well, you answered or you actually asked one of my other questions, so I'll ask my other one. Any idea on what you are looking at for rent? A
We'll
window?
probably be in the neighborhood of $225 a square foot, something along there will be. So what we do is we look at our competitive set and basically set the rental rates based on what similar product types in the immediate submarket are.
Okay, thank you.
What is your project timeline? How many months or?
We are currently working through that with the city. I think we anticipate starting construction within roughly 15 months from site plan approval. So if we're lucky enough to get it today, that kind of kicks off the rest of our design.
Other questions from commissioners?
Yeah, this one might be, I don't know if it's a staff or developer. So currently, we have the street between the Star Center and the old CFB ISD building is shut down, and, you know, it's closed. But you're saying it's going to be 15 months before you start construction there? And with the I-35 construction, the traffic backs up along the access road all the time now, way past that. And yet we have this road there that's been closed in anticipation of this. And yet I'm hearing it's 15 months out before we start building. Can we open that street back up? I mean, I know it's sort of this is back to staff. I mean, I don't know how, right place to put that, but it just, are we going to have a 15 months place where we're going to have a street sitting there that we can't use, I guess is my question.
Yeah, the short answer is just yes. Unfortunately, I mean, yes, in the sense that we can't open it back up because the right-of-way's already been abandoned. So we could never, from this point forward, unless the city takes that goes back on the abandonment and turns it back into right-of-way,
Right.
it is abandoned officially. And so there's really, your option right now is really Pike Street. And we just have to hope and pray these guys are going to build this project quicker. No, I'm joking. Unfortunately, yeah, it's abandoned. So that's kind of where we're at right now, unfortunately.
Yeah, a lot of people have asked that question.
Sure,
And it's good
absolutely.
to know the answer. Thank you.
Absolutely.
Any further questions for the applicant or for staff? This is a public hearing, so we will go ahead and open the public hearing. If you do have comments for the public hearing, you may approach the podium and state your name and address for the record. And you do have a time limit of 3 minutes available.
Hi, my name is Funa Purath and I live on Charlie Bird. So the question that we have to continue the same discussion about the street that's condemned for a few months now, and we are taking the alternative street, which is really not a street. It's kind of almost like a parking with a lot of holes. And when you are there in your car, in order to get to the service road, you almost have to jump to get down there. So is there any way you can fix that street? And is there any way we can have a normal street, not just kind of like a parking? Also, when is the demolition going to start of the old buildings?
Thank you for your questions, madam. We can direct those questions to staff in terms of attempting to answer those after we close the public hearing.
Okay, thank you.
Thank you so much. Anyone else for the public hearing? Okay. Commissioners, this is a public hearing, so we will first move to close the public hearing. If anyone wants to make that.
So moved.
Thank you. And a second?
I second.
All right. All those in favor to close the public hearing? So there's no other discussion? Yes. So that carries. As the public hearing is now closed, we will now, thank you, madam, for your questions. I would like to pose those to staff, just if there is again, as our statement says, a statement of public fact to answer those questions.
Sure. I know exactly where she's talking about too, because I take Pike Street every day and it drops off pretty hard right when you get onto that frontage road. I can talk to our Public Works Director, Ryan, about that. I do feel that some of that might have something to do with TxDOT right-of-way. I'm not exactly sure where their right-of-way starts and where ours begins on that road. But if I can get your phone number and email address, I can follow back up with her on some details on what the city can do or what we have within our power of what we can do about that. Now, again, if it has something to do with the Texas Department of Transportation, I can get her the correct information on who to contact for that. Demolition of the existing building that's out there, that's really going to be contingent on if we get this thing going and get this approved. I'm assuming you guys are ready to demo that building here pretty soon, or for the most part. So, yeah, I don't know if we can actually give like a month time frame. That really would have to be on the applicant to answer that question, I think.
And of course, contingent on receiving approvals.
Correct. And also, we are working with the city, because this is currently city-owned property, to purchase this. And I would imagine as we get closer to finalizing a purchase and sales agreement and actually becoming the owners of the property, that's something we can certainly look at doing. And I would imagine the PSA is likely first quarter or end of this year, so.
Thank you for that update.
No
Very
problem.
much
One
appreciated.
real quick question. On the demolition, are you doing anything to mitigate any dust and that kind of stuff?
Yeah, we would we would hire a contractor who specializes in
Okay,
that,
thank
and they would do the appropriate things.
Thank you so much for clarifying.
No problem.
All right, any further discussion from commissioners? Comments? All right, we do have a number of actions in front of us if,
As far as making a motion,
yes.
I'd like to make a motion to recommend approval of the requested special exceptions as presented.
Thank you.
I'll second it.
Any further discussion? Seeing none, we'll move to a vote. All those in favor? All right, that carries unanimously, and this will go to City Council. No, because it doesn't have to, that's right.
Yeah, this is the plan development only requires that it goes to this board, does not have to go to the city council.
Fantastic.
So your word is final.
Thank you for that. All right. Congratulations. We will look now to item D2, to conduct a public hearing and consider the request for a specific use permit for a commercial amusement development on approximately 1.55 acres located at 2330 Jet Street and take appropriate action. Thank you, Sarah.
Thank you. Good evening, Commissioners. Sarah Bergman, lead planner. This site is located at the corner of Jet Street and Denton Drive within the city's station area, or PD 86. The site is developed with an existing warehouse building that was constructed in the early 70s and is currently vacant. And the applicant is proposing to redevelop this building for a new pickleball entertainment venue. Any commercial use within PD 86 or commercial amusement use within PD 86 requires approval of a specific use permit. This is a floor plan of the proposed development. It does show 6 indoor courts and 4 outdoor courts, as well as restaurant and seating areas and outdoor seating. A number of streetscape improvements are proposed as well. The development is meeting minimum landscaping and parking requirements for PD 86 as shown here. 19% open space is being provided for the site, as well as street trees at 30-foot spacing. And the minimum parking requirement for the site is 21 spaces, and 55 have been provided. In addition, PD 86 requires specific streetscape standards for each frontage, Jet Street, Denton Drive, and Valley View Lane. And that includes new sidewalks, on-street parking, street trees, landscaping, lighting, and outdoor seating. And so the applicant has met all of those requirements. Because this is an existing building, the applicant is proposing several upgrades to the building facade, including new windows, canopies, lighting, entrances, and paint. And the applicant is also proposing to install 2 new murals, one facing Jet Street and one facing Denton Drive. PD 86 encourages the use of murals, and the site is also located within the city's Arts and Culture District. And this is just a comparison of the existing building elevations and what's proposed. Here are a few renderings, one of the main building entrance, one of the outdoor seating area along Jet Street, and one of the outdoor court area. And this development does align with both the Farmers Branch 2045 Comprehensive Plan and the IH35E Corridor Revision Study. Both of these plans recommend a mix of uses in this area, including entertainment and retail uses. And the I-35 plan designates Jet Street as a priority for new sidewalks, which is accomplished here. We did send zoning notification letters to all property owners within 200 feet, and no written response has been received. And staff does recommend approval of the SEP request as proposed. I'd be happy to answer any questions, and the applicant is here as well.
Commissioners, any questions first for staff? All right, seeing none, and the applicant is here. Will we have questions for the applicant? I understand the applicant, in this case, does have a presentation.
They have one if y'all would like to see it, or they can just be available for questions.
I think, at least personally, I'd love to see your presentation if you don't mind. Yes, please, and you just state your name and address for the record.
Brilliant. G'day, Commissioners. My name is Mario Simic, and my address is 6175 Vickery Boulevard in Dallas.
Thank you.
All right. Yeah, sounds good. You want me to say yes or? No. Okay, fair enough. Team, so the facility, we're going to call it At Fault, kind of a play on words with regards to pickleball. So there we go. As mentioned, it really is an entertainment concept. The goal is to provide not just pickleball, but an elevated component around food and a bar that we're going to have, combining both indoor and outdoor, and really kind of creating this family-friendly atmosphere for folks who want to play pickleball, but also for folks that just want to come in and grab a bite, do some work, or maybe do a combination of both. This is the team. I'm the only one present here today, but I do have a couple of partners involved in this process. All of us have various backgrounds that has really led us to this project. And yeah, so we got myself, Chris, and Bo as part of the effort. In conjunction, we've tried to align ourselves with some very strategic partners. So we talk about an elevated food concept. We've partnered with Chef John Frankie, who's had a core role in designing concepts like 60 Vines, Ida Claire, Whiskey Cake, some really great Dallas staples. And we wanted to bring that to align with the things that you guys have done here with regards to restaurants like Roots and the brewery that's coming up and kind of all the changes that are going on within the city. So we've gone through a little bit with regards to what it looks like today. That's the outside as well as the inside. And you've seen some renderings as to how we envision the future space looking. From an internal side, we're going to have kind of a 80s, a little bit of a throwback, country clubbish kind of feel to provide that elevated experience for the guests as they come in. We've got some unique ideas with regards to how we're going to accomplish that, but this is the basis as to which we're building the internal space. You all have seen this. The plan is that we own the land and we are committed to providing a significant amount of investment to get it to where it needs to be. And we do plan on having a long-term relationship with the city and the community. Some core components as to why here. We've spent a fair bit of time thinking about where we wanted to bring this concept to life. And I've spent 12 years now, 13 years in Dallas. And when we found this location, it just felt like home, right? It's at the heart of everything when you step back and look at the Metroplex. And we just fell in love with the location and really where the city's going. So we wanted to be a part of the vision that you all have created. And there's just a lot of great things that are happening in the community, mentioned by some of the other applicants that are here, and some things going on around the facility that's being built, the Stars facility, the event centre, and then again the restaurants and breweries that are being put forth right here. As you guys know, pickleball is pretty hot. Also, this notion around entertainment spaces is also very, very hot. So we wanted to kind of ride those waves, right? There's significant demand for both, and we wanted to marry those. Farmers Branch is hosting the Pickleball Championships, and we believe that again kind of adds to this vision and allure that is pickleball and aligning it to the community. A number of other statistics over there that are kind of supporting the fact as to why this should be a pretty decent success in the community. Statistics here around pickleball. Happy to dive deeper into any of these, but just wanted to kind of provide that. And ultimately what it boils down to is this partnership, right, around the community. There's a low barrier to entry when it comes to pickleball. So anyone can play, young, old, all different skill sets. It's really about bringing the community together. We anticipate phase one driving close to 60 jobs, and those are kind of tied to some lower end projections that we have. And in terms of tax revenue for the city, we anticipate not only 5xing the tax base in the building itself, but also driving north of $60,000 in revenue to the city as well. And then you couple that with the exposure, again, with some of the things that you all are doing. I've been to parts of Dallas to play pickleball that I would have never gone to, and it's a fair bit away. I think this is the spot. Like, why do we not want people to come to Farmers Branch and experience what the city has to offer? From a numbers standpoint, done a fair bit of research around different cities, different concepts. We feel extremely comfortable with what we've put forth here, but this kind of justifies or backs up a little bit of the tax revenue numbers we've put forth in front of us. And yeah, some core components around why we think this will be a success. It's about providing just that better, elevated kind of an experience that drives beyond each individual component that together provide something that's pretty unique in the town. And we combine that with the right partnerships within the DFW, as well as a lot of the skill sets that my partners bring to the table. And and you couple that with a sport that's pretty easy to play and actually really fun, so you can be social or competitive. We think it's a pretty unique and winning formula. So that was kind of flew by us with that presentation.
Thank you. And I do believe we had a couple of questions. Okay.
I was going to mention if you might want to put on this presentation when you do it again, that Farmers Branch emergency medical services are generally about 3 minutes away.
Yeah.
So I think that's going to be a real plus for some of your older people like me that go into that facility.
3 minutes, huh?
Yeah, less than 3 minutes.
3 minutes, yeah.
Also, is that warehouse tall enough to
It is,
hit
yeah.
a ball?
Yeah, we've gone through it, and we've got plenty of elevation in there for pickleball.
I think this is really a great idea. I think it's smart. I think you'll be successful. And when are you going to get started?
The goal is from here to go to council next week, and the plan is if we get the green light from the city to get permits, go for the permits next day. We have a pretty aggressive plan, and we're working with our GCs and kind of a pretty large team in the background to stage everything in the hopes that we can get the green light. Our aggressive opening date is March 1st. We want to be ready for March Madness and ideally take advantage of some cooler weather.
That's great. Thank you.
I've never played pickleball before. How's the fee structure work? Is it going to be a membership? Is it just by the hour? How does it work?
Yeah, we've got a combination of things. There are folks that are obsessed with pickleball, so we'll cater to those in the forms of memberships. We have different tiers that we have proposed, and also for the casual players that want to come in and do that. We have a website where you can go and reserve a court if you do want to just play with your mates, or if you do want to have a corporate event, birthday party, whatever it may be. We'll cater to that as well. As you saw in the plans, we can kind of partition the facility to meet the demands of the customers.
Thank you.
Yeah, no worries.
Yeah, so just curious about the sort of the physical structure of your dining and bar. Is there going to be like an actual restaurant and a bar area, or is it more decentralized like Topgolf where people are eating, where they're playing? It's like, would I go there on a Friday night with just to have drinks and food?
Yeah, no, absolutely. Yeah, so if you let me see if I can go back to this real fast. Be a bit easier to chat. You guys able to see it on the screen? So yeah, we've got an indoor and outdoor bar on the north and the east side, and the kitchen's in that northeast corner. So it'll have that restaurant feel if you're going there just to grab a bite and hang out, or if the weather's great, we'll have the ability to have an indoor-outdoor setup as well. But if you're there to go and play and then have a drink after, we'll be able to cater on the courts as well. So you can work together or separate as well. Yeah, you bet.
Okay.
I'm sorry.
Go ahead.
The surface outdoors that the tables are setting on, is that decomposed granite, cobblestone, concrete? What?
I'll probably get one of the teams to tell you exactly what it is, so I don't know. Oh, yeah.
Okay, thank you.
Sorry, mate.
Yeah, I had a few questions more tied a little bit to public safety and the residents and your clients that may be visiting there. Just to follow on with Commissioner Freilich regarding our top-notch fire department and EMS service, do you plan on having any first aid capabilities and EMT on site or anything for injuries?
I think whatever the requirements are from a first aid perspective, yes. But
I don't know that we have any. I just didn't know as a general business if you had business insurance that requires such a thing, or I don't know.
We'll align with what's required and what we think is best practice for the space.
Okay. And There are some electric power lines on the north side of the building. Are they planning to remain as is, or are you going to move them underground, or?
So I think we've looked at those and, yeah, I mean.
Just leave them as is, or are you going to move, do any?
And just go ahead and state your name.
Yeah.
Good evening. My name is Michael Clark. I'm with Winkleman and Associates, 6750 Hillcrest Plaza, Suite 215, Dallas 75230. The power lines you're talking about on the east side?
I'm sorry, yes.
No worries. I didn't remember any on the north side, so I was
I
confused.
misspoke, sorry about that.
We looked at putting them underground, but what we're trying to do right now is the main power poles, we're trying to get them cleaned up with removing some transformers. One
Okay.
looks to be dead, one's for our building that we're going to put on the ground mount. And those low-hanging cable lines, we're going to try to get those put on the regular pole, so at least it looks more regular and not such a hodgepodge.
Yeah, it goes right to my point. I was over there today and I noticed some of those exact same things you're mentioning.
Yeah, we started down the path of underground, and there's so many lines there and so many different companies. We just thought cleaning it up would be more practical.
Okay. Okay, great. Other question I have is regarding the outdoor courts along the Valley View Lane. I believe you can plan to have an 8-foot fence along there. Is that fence going to be a privacy type fence, or is it going to be open to view from drivers driving by? That's number one. Number two is, do you think the fence is high enough to prevent balls from getting out into the roadway, causing cars to have to maybe dodge a ball or something? Or?
You can grab the fence, I can talk about the rule.
Okay, the fence, at least our proposal is to have it to be visible through. That's the plan right now. We're working with Encore to get full approval to put what we want in there. A little disagreement with them on what the easement says, but that, our proposal is a metal fence, 8 foot, where you can, with visibility through it, and I'll take a shot at the balls. It's 30 or 40 feet from the fence to the street, so
I'm not a pickleball player. I don't know how high balls or how far they go, so I don't.
You'd have to hit it.
wouldn't know,
You'd have
so.
to really try to, especially with the courts going parallel with Valley View. It'd be a tough shot to kick it out there, I think.
It's a wiffle ball, so it ain't.
Yeah, okay,
You can't
okay.
get by, yeah.
And last question, will those courts be lighted at night?
I'll have to get back to you on that. The reason, because of the discussions with Encore, I think we have to figure out like how.
Okay,
how
that's
that
fine.
would go. So,
Thank you. Thank you very much.
yeah, you bet.
Any further questions? All right, this is a public hearing, and we thank you.
Thank you.
For your comments.
What, leave this up? Or?
Yep. This is a public hearing, so I'll give an opportunity if anyone wishes to speak in the public hearing. All right, seeing no comments, we will move, make a motion on the public hearing. Yep.
I'll move to close the public hearing.
Thank you.
I'll move to second it.
Seconded. Any further discussion? Seeing none, we'll move to a vote. All those in favor to close the public hearing? That carries. Okay, unanimously, just double checking. Thank you. So any further discussion on this? We do have a number of actions.
I'd like to go ahead and move that we approve the, as presented, 2330 Jet Street, as presented.
We have a motion to approval, to recommend approval of the special use permit as presented.
Second?
And second, any further discussion on the matter? Seeing none, we'll move to a vote. All those in favor? All right, that carries unanimously. And this will go to City Council September
September 19th.
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 Thank you so much. We appreciate it. And seeing no other items on the agenda, we will adjourn. It is now 7:56 p.m. Thank you.